January 6th, 1959, Richard Loving and his wife Mildred were sentenced to a year in prison after they pled guilty to committing a felony in the state of Virginia. Their crime was that they were married to each other. They'd gotten married in Washington, D.C., and then driven back home to Virginia, and state law in Virginia said not only could a mixed-race couple not get married in Virginia, but if a mixed-race couple got married anywhere else and then tried to come live in Virginia as a mixed-race married couple, that couple would have to go to prison. 1 to 5 years in prison for the felony of a mixed-race marriage in Virginia. And on January 6, 1959, Mildred and Richard pled guilty. They were each sentenced to a year in prison. The judge told them they would not actually have to serve that sentence. They would not actually have to go to prison. The sentence would be suspended if they agreed to leave the state and get out of Virginia. And they did. The Virginia trial judge who sentenced them said this in his ruling. He said, "Almighty God created the races white, black, yellow, Malay, and red, and he placed them on separate continents. And but for the interference with his arrangement, there would be no cause for such marriage. The fact that he separated the races shows that he did not intend for the races to mix." That was in the judge's ruling. And that is how Mildred and Richard Loving faced either prison or banishment from the state. In all of the political arguing and kitchen table debating and even the courtroom litigation around the issue of same-sex marriage, the case of Richard and Mildred Loving and the legality of their marriage, it comes up over and over and over again. People use it as a civil rights analogy to explain how the laws around marriage haven't been static for all time. In the relatively recent past, certain kinds of marriage that we now accept as totally legitimate were banned by law in some parts of this country. The Supreme Court case in Loving versus Virginia, which overturned that state law which banned their marriage, that Supreme Court case, and the eloquent ruling in that case written by Chief Justice Earl Warren for a unanimous Supreme Court, that ruling has been cited over and over again as both an analogy and as precedent for the courts now striking down state laws that ban same-sex couples from getting married, just in the same way that Mildred and Richard were banned from getting married because of their race. But tonight, in the state of North Carolina, Republicans in the state legislature there are about to pass an anti-gay marriage law that does not just remind people of the Loving versus Virginia case. It doesn't just invoke Richard and Mildred Loving as an analogy, as a reminder of when southern states would not marry mixed-race couples either. What North Carolina is about to do would not just remind people about banning interracial marriage, it would actually allow for that again. This North Carolina bill already passed the legislature, was actually vetoed by that state's governor, but the Republican-led legislature in North Carolina is in the process of overriding that veto and putting this thing into law anyway. The Senate has already overridden the veto. The House looks like it's about to override the veto, and that will make it law. This bill was written as an anti-gay bill. Right? Federal courts have ruled that same-sex marriage is legal in North Carolina. The state has to recognize the marriages of same-sex couples. But this bill would allow court officials in North Carolina to refuse to grant those marriage licenses anyway. Right? So the idea is, sure, technically same-sex marriage is legal here. There are these federal court rulings telling North Carolina what it has to do in terms of the Constitution. But this legislation would let individual public employees who are the gatekeepers to letting people actually access that right, it would let those public employees opt out of doing so. It would let those public employees opt out of allowing people to access their constitutional rights in North Carolina if that public employee, as an individual, just didn't want to do it. Under this new law in North Carolina, public employees in charge of handing out marriage licenses could refuse to do so to any would-be married couple that the employee objected to on the basis of their own personal, religious, or moral beliefs. So, in other states where Republicans have pushed legislation like this, there has at least been some nod in the legislation toward the state still having to uphold the law and meet its constitutional responsibilities. But in North Carolina, this new law is a blanket change. It puts no restrictions on what a person is allowed to express their religious objection to. So, depending on where you live in North Carolina, your local magistrate may only agree to give marriage licenses to straight couples. Next county over, the magistrate may believe it's her moral duty to only give marriage licenses to couples who are the same religion. A Jew and a Catholic? Are you kidding me? I'm not going to allow you to do that. That's against my religious or moral beliefs. Sure, it's constitutionally protected, but my religious and moral beliefs trump that. Under this new law that the North Carolina legislature is about to enact over the Republican governor's veto, any county magistrate may turn away any couple who applies for a marriage license on any grounds, as long as the magistrate says the reason they're objecting is in some way related to their religious faith. And I don't know if there are county magistrates in North Carolina who agree with that Virginia judge in the Richard and Mildred Loving case, right? That God put the races on different continents for a reason, and if we hadn't screwed it up, we'd never have a need for these anti-race mixing laws. Right? Who knows if there's a county magistrate somewhere in North Carolina who believes that interracial marriage is sinful and not what God intended, and it's against their religion. But North Carolina Republicans are about to pass a law that would tell such a county magistrate that that is an acceptable basis on which a marriage license can be denied in North Carolina. Constitution and Supreme Court be damned. They were aiming at gay people. They hit everybody. Again, that bill passed the House and the Senate already in North Carolina. It was vetoed by the state's Republican governor, Pat McCrory. The Senate last night overrode the governor's veto, and the House in North Carolina is poised to do the same, which will make this thing law. And North Carolina, once again, will be way out on a limb in terms of, the arc of history bending one way, and North Carolina banging at that arc with an iron bar, hoping it breaks off. Amazing. Watch this space.